It had been a very busy day, and my plans to have a shorthand themed day went out of the window. There was no time to look up words in the dictionary, make notes of special outlines in the shorthand folders, record the dictations, or clean out all the fountain pens. It would all have to wait until tomorrow. Once in bed, I turned out the light and tried to listen to a talk on the iPod, but despite seeing all the outlines appearing as the words were spoken, I soon had to switch off and give in to slumber. After a short while of peaceful, inky blackness, the outlines reappeared. I was in a large office. There was a distant, faint voice speaking, and I saw my hand writing furiously to get it all down. The pad seemed to have only one sheet in it, and my outlines grew smaller and smaller in the hopes of fitting them all in. I reached the last corner, and then I had to resort to writing on the table, and then up and down the walls and across the carpet. No time to stop and find more paper. How would I ever read any of it back? I was not even sure there was any ink coming out of the pen. Or maybe it was a blunt pencil, or even a piece of wood, or an old drinking straw. Fatigue and weariness defeated all my efforts, and the scene faded from view. All of a sudden, there was a rustling of papers and scraping of chairs. I looked up and found myself in a courtroom. Was this a magistrate's court, a federal court, a district court, a trial court, a state court, or maybe the Supreme Court? It seemed to be a trial by jury, and the jurors sat motionless and emotionless, waiting for proceedings in the judiciary process to begin. In front of me was a stern-looking judge, rearranging the documents before him. Somehow I caught sight of the heading of the documentation: Shorthand Crimes and Charges. What was my alleged misdemeanour, and why had I been taken to court? Was I being accused of the offence of negligence, nuisance, or disobedience? Or maybe malpractice, or forgery in relation to intellectual property? Would legal action be taken against me, and a restraining order issued. If there had been a robbery, a burglary, something stolen, vandalism, arson, embezzlement, assault, a kidnapping, a hijack, manslaughter, or a murder, homicide, or even treason against Queen and country, then obviously this was a grave case of mistaken identity. I knew no crime or offence had been committed, and I could only come to the conclusion that it was a case of slander against me, or possibly bribery by an enemy with bankrupt morals, and I would certainly be able to counter these criminal accusations with a claim for defamation of character. I looked round, and by my side was an oldish gentleman with a white beard and friendly face. He was smiling broadly and showed me his business card. Sir Isaac Pitman, Shorthand Defence Attorney and Stenographic Advocate. Things were looking up, and as I glanced at his papers, I saw a long list of witnesses that he was intending to call, although I could not quite read the names. Suddenly I felt much better. A lawsuit culminating in imprisonment in Shorthand jail was no longer threatening me, and justice would be the outcome. The first charge was read out, scribbling the outlines. How does the accused plead? I had indeed scribbled them many times, and was about to reply, when Mr. Pitman quickly spoke up. Not guilty, Your Honour. I was amazed. The defendant wrote the outlines exactly as I recommended when I created the system, in a manner in which they could be read back, and she did indeed transcribe them accurately. Therefore, I challenge and dispute this accusation, and I claim that scribbling is, beyond all reasonable doubt, neither a crime nor a felony, and certainly not a breach of statute law, common law, or business law. I call my first witness, the defendant's shorthand teacher. She stepped up and began to explain how she taught us to write perfect outlines, and then, later on, encouraged us to write more flowingly in order to increase speed. She confirmed that it was impossible to write outlines as neatly as in the book when going at high speed, and that those had been laboriously engraved in order to be a perfect reference point, which real-life writing should aspire to as closely as possible. The judge seemed satisfied with this explanation. The jurors began to look more relaxed, and I think I saw the corners of their mouths smiling in agreement. The next charge was read out. Not using dictionary outlines. How does the accused plead? It was true that I had written some unorthodox outlines, although I had always been able to read and transcribe them without difficulty. I was about to answer to that effect when Mr. Pitman once again rapidly stepped in to argue against the accusation. I do not think my client needs to answer that charge, as it is not based on any legal requirement to use particular outlines. The only time dictionary outlines are legally required is during an examination, to prove that the writer has performed satisfactorily using the system stated, and so that the certificate is accurate. And in those cases, marks are likely to be deducted for incorrect outlines. At the time my client used non-dictionary outlines, she was not in an examination, nor, for that matter, writing material for publication. I would like to call my next witness, the editor of the Shorthand Dictionary. The editor was ushered in and began to read out excerpts from the introduction to the dictionary, repeated over all the editions, which are as follows. There will no doubt be differences of opinion with regard to the outlines for certain words, since a form which is the most convenient to one writer is not invariably so to another writer, and no dictionary outline, therefore, should be rejected in favour of another until an attempt has been made to ascertain whether there is not some special reason for its adoption. And finally, every writer of the system is aware that there is often a choice between two or more possible shorthand forms, and the dictionary provides those outlines which experience has shown can be recommended for general adoption. Mr. Pitman continued with his refutation of the charge. This proves that they are recommendations and not legal requirements, although I would strongly suggest that the dictionary forms are followed. The judge solemnly turned over to the next page of his documentation, which I took as a good sign that this point had been defended satisfactorily. No stenographic wrongdoing had been committed, and therefore no penalty or punishment could be enforced upon the alleged perpetrator. I was beginning to feel more vindicated than victimised. The next charge was similar, and the prosecution were smiling and smirking, in full confidence that this one would bring me down, leaving gaps in the shorthand notes, a clear dereliction of duty and proof of total incompetence. How does the accused plead? How could I deny that I had left gaps at some time? I turned towards Mr. Pitman, who smiled and immediately put forward his refutation. My client and I would like to know which is the worse offence, leaving a gap of 1 word or leaving a gap of 10 words. The judge ordered the prosecution to answer, and they grudgingly agreed to the latter. My client has occasionally had to leave a gap. If she had stopped to ponder on the outline, then there would have been a gap of at least the next 10 words. In mitigation of this rare shorthand failing, she always attempted to go back and put it in the margin when there was a pause in the speaking. I feel this course of action has saved the prosecution much distress and anguish by reducing the size of the temporary gaps left. The resultant difficulties were always cleared up eventually, if not by memory or common sense, then by consulting the speaker, a most commendable practice, where accuracy was obtained at the painful expense of having to admit one's shortcomings. I hadn't really thought of it quite like that before, and neither had the prosecution, to their chagrin. Another charge followed, not consistently using margins in the notepad, and therefore bringing into jeopardy the quick insertion of headings or corrections, and the rapid finding of a particular paragraph for immediate transcription, or to read back to the person speaking. How does the accused plead? I had always filled every notebook with pencil margins of about 2 centimetres, but occasionally a page had turned up without one drawn in, or I had to start a new, unprepared notebook with no margins present. Unfortunately, this accusation appeared to be quite true. Mr. Pitman once again had an immediate answer. The accused has written very rarely without the essential drawn left-hand margin, but on those occasions she merely refrained from writing in the first left-hand inch of the page, and therefore I put it to the court that a margin was in fact used. Drawing it in, where it is not pre-printed in the pad, must be considered an optional extra, and a highly recommended and useful one, but it is the use of a margin, not the pencil line, that is in question here, and I assert that the defendant has never written any shorthand without leaving a margin space for extra notes. It is my opinion that this accusation is therefore fundamentally flawed. The next charge was brought: not using an ink fountain pen at all times, and unauthorized use of a pencil. How does the accused plead? I had indeed used a pencil, and to deny it would be perjury. I knew by now that it would be better to let my excellent and indefatigable attorney answer. Mr. Pitman said, "I would like the prosecution to consider whether a speed of 150 words a minute is a worthy achievement or not." The judge allowed them to reply, and they resentfully agreed that it was. My client was instructed to bring several pencils to the first shorthand class, which instruction she obeyed. At a later date, she was given a clutch pencil to save having to sharpen the pencils or suffer the inconvenience of sudden, broken or wobbly leads. With this, she eventually passed the aforementioned exam. In later years, personal funds were available to buy some shorthand fountain pens, which improved the writing speed and quality, and therefore the readability and durability of the notes. Pencil was never used again, and we agree that ink writing is much faster, as long as the pen is of good quality and not scratchy. However, the foregoing are merely suggestions to achieve higher speeds, and we are here concerned with the actual usage of pencils in all kinds of shorthand note-taking. He continued, "Once my shorthand system became more widely known, it was eagerly taken up by reporters who realized that making quick notes in the street, possibly in the rain, required the use of a pencil and not a dip pen. And I believe many of them used both, depending entirely on the situation in which they had to discharge their duties. They also needed to use pencil in low light conditions, where they might smudge the previous line of writing, or not be able to see the ink pot, for example in counsel meeting rooms. This was despite my strong recommendation to use the phono shorthand pen wherever possible, which I believe was the best of its kind at that time. Pens are greatly improved nowadays, but the most relevant fact is that no law has ever been passed that required the use of ink at all times, and it is left to the writer to determine which to use, according to the circumstances and necessities prevailing at the time. I was relieved to hear that past high-speed reporters had enjoyed great success with pencil, and had not been left to read soggy ink notes from being on the job out in the rain. This line of defence also boded well for present-day students who could not get hold of a good pen, and that they too could achieve 150 words a minute or more with a traditional pencil, without fear of prosecution in a court of law. The last charge sounded extremely serious indeed. Negligence in leading innocent students onto a path of study, resulting in difficulties, confusion, late nights, exhaustion, anxiety, and either obsession or disillusionment. How does the accused plead? I felt I could probably answer this, but Mr. Pitman raised his hand so that he could speak first. Not guilty to all charges of alleged misconduct, malicious, harmful, and misleading procedures of shorthand dissemination and abandonment of responsibility to writers and learners. I present Exhibit 1, a list of complaints by non-shorthand students on the exigencies of taking their journalistic notes and minutes of meetings using only traditional longhand. They complained of difficulties, confusion, exhaustion, and late nights in a state of anxiety at how they would read back their scrawled and incomplete longhand notes. These were illegible, either because there was no time to write the words in full, or they had made impromptu abbreviations, untested and untried, which were later found to be ambiguous or misleading. This left them disillusioned at the impossibility of writing complete notes, and indeed the time spent resolving these avoidable difficulties could have been spent learning a reliable and proven shorthand system. I am glad to say that some became obsessed with finding a solution to this, and fortunately discovered that shorthand instruction material was easily available. I would like to call my witnesses, namely several shorthand students, who can provide evidence to refute the accusations made. No habeas corpus or subpoena has been necessary, as they are all very willing to testify in this court. Mr. Pitman sat down, and in the excitement I was able to catch just a few of their comments. Yes, there were difficulties, but I overcame them with hard work and got my certificate. At first I was confused, but as I reread the chapters, it all became much easier, and I obtained my certificate. I had many late nights but this meant that I could sit for and pass the exam several months early. There was a lot of anxiety before the exam, but once I started writing, I was glad I had studied so well, and I gained my certificate. I became quite obsessed with shorthand, and this resulted in earning my certificate much earlier than anticipated. I became disillusioned with shorthand at the end of the first chapter, but I realised that I was not going to be writing fast until we had covered all the strokes. I persevered and gained my certificate, and I am working towards the next one. Now I am disillusioned with handwritten longhand, at least as a means of writing lots of material very fast and accurately. Mr. Pitman had shrewdly saved the best one to speak last. I got extra shorthand practice at college by taking shorthand notes in all the other lessons and lectures as well. This led to me being able to gain first-class passes in all the college examinations and the highest speed in my shorthand class exams. Mr. Pitman continued, "These statements speak for themselves, and I contend that the accusations made by the prosecution are unjust, unfair, and completely unfounded. And I can only conclude, based on observations of my own students in the past, that such an opinion generally comes from someone already disillusioned or anxious, which would be rapidly dispersed and dispelled if they only took the time to speak to those who had already achieved their shorthand goals." These allegations are mischievous in the extreme, and my client merely offers the means to learn and improve. No evidence whatsoever can be found for coercion to make students continue their studies beyond their own requirements, abilities, and comfort levels. I was so glad I let Mr. Pitman speak for me. After an adjournment of 2 hours, the hearing continued. We were all quite relaxed and confident, but the prosecutors were looking decidedly pale and nervous. Their implications of the unlawful nature of my actions in shorthand writing were likely to fall foul of the judge's ruling and his interpretation of any regulations appertaining to the subject. As I looked at the jurors, I felt that I recognised them all as my commercial course teachers and shorthand colleagues from college. But maybe this was an illusion, as they would probably not have been allowed to serve if they knew me. The judge spoke at length on the proceedings and read out his final judgment. He concluded that this came close to a mistrial due to improper evidence, although he did concede that the evidence was merely inadequate due to their ignorance of the subject and failure to check their facts. He was confident that his decision would not be overruled by any higher court, that the accused was completely exonerated, and all the ill-conceived allegations, infringements and grievances put forward by the prosecution were successfully responded to and countered by the defence counsel. Notwithstanding this, he commended the prosecution on their brave attempt at protecting the interests and possible delicate constitution and mentality of past and future students. The jury's completely impartial judgment and decision was that all of the prosecution's evidence was insufficient and should be rejected immediately. No condemnation was relevant, no guilty verdict could be arrived at, and no sentencing was required. They declared that this litigation was poorly thought out by the prosecuting attorney. The judge commented that it was not in his jurisdiction to suggest how the defendant should write shorthand or what implements to use, and that this would be left to the advisory committee, who would be consulting all the shorthand books written over the past nearly 2 centuries, from the time of Mr. Pitman's creation of the system until the present. This would include those of other systems who have come to many similar conclusions, and whose minor differences of opinion are largely immaterial to the attainment of reliable high-speed writing. Mr. Pitman was nevertheless commended for his eloquent appraisal of the situation and his attention to detail in his defence of the accused, obviously a quality he had perfected whilst working on the creation of and revisions to his system of shorthand writing. In deference to the counsel for the prosecution, in order to deflect attention from their miserable failure in bringing their grievances to court and obtaining condemnation and a conviction, the judge expressed the opinion that shorthand writers were already willing and happy prisoners, undergoing a life sentence of shorthand fascination, which, however, seemed only to lead to improved performance and increased job satisfaction. He also noted that the traditional longhand was itself struggling against a virtual death sentence imposed by the ubiquitous computer keyboards, audio recording devices, and speech-to-text programs. He concluded by suggesting that interested parties should study shorthand for journalism and personal notes, stenotyping for court work and captioning, longhand for personal letter writing and calligraphy, and computer studies for everything else. I looked around the room to see who the plaintiffs actually were, but they were all bending down, packing away their papers for a quick exit. As the court was dismissed, my eyelids began to get heavy. But then, all of a sudden, I opened them, and I saw the sun streaming through the curtains in my bedroom. How could I have lain in bed, wasting a couple of hours of early morning daylight, when I could have been doing all those shorthand jobs left over from yesterday? But first I would make a quick draft of my strange courtroom experience.